Analytics. It's hosted by Joe Hadzima and Alex Butler. In just a few minutes, we're going to begin the webinar. But first, given the large number of attendees, including roughly 100 individuals with 50 organizations, we'd like to mute all the phone lines during the presentation. Please submit questions using the question panel of the web meeting software. Joe and Alex will address questions where possible during the presentation, and also we'll have a closing Q&A session. Also, by attending the session, you may receive results of a specific patent claims analytics report to help you take advantage of the capability outlined during the presentation. Additional instructions will be provided at the end of the session. Now, I am pleased to introduce our presenters. First, Joe Hadzima. Joe is the CEO of IPVision and a senior lecturer at the MIT Sloan School of Management. During his legal career, Joe was the managing partner of the technology practice of Sullivan & Worcester and has counseled literally hundreds of firms through inception, capital formation, public offering, acquisition, and on occasion through less favorable circumstances. The lessons learned through his decades of corporate representation, board membership, academic leadership, and community involvement as a leader in the MIT Enterprise Forum provide unique insights into how to prime organizations for effectiveness and sustained competitive advantage. Joe is joined by Alex Butler, an Executive Vice President at IPVision and member of our senior leadership team. Alex is a longtime leader in the IP community, having worked in the leadership of Thomson Reuters' global IP business, IHI, known for its MicroPatent, MDC, and Orion Solutions brands, and leading legal information management software and consulting firms. Alex's systematic and strategic approach to helping organizations design and implement improved decision-making platforms and processes provides a welcome change to firms seeking to move beyond traditional practices. So now let's turn our agenda. While this presentation is focused upon one specific analytics technique, Joe and Alex will work to provide context, specific examples, and most importantly, actionable recommendations for how organizations can use this and other similar techniques to create and preserve defensible, lasting competitive advantages. Please do submit questions as they arise. We look forward to our conversation, and without further ado, I'd like to introduce Joe Hadzima. Joe, I will pass it off to you.
Joe, thank you for the introduction. As indicated, this session will focus upon the topic of how leading corporations, their outside counsel, and other expert advisors leverage patent claims analytics to gain advantageous information over competitors and adverse parties, and how they use this information in broader operational strategies and tactics. While not the only analytic technique available, we feel that this patent claims focus provides a unique perspective which previously was not available. Data analytics in their own right provide fundamental advantages for those organizations who move to data-driven insights and exploration. In terms of technology businesses, we know from common sense that patents are important. However, as we will see, a few barriers remain. IPVision and the patent claims analytics remove these barriers by reducing cost, increasing speed, providing increased focus and situational awareness while maintaining a deep respect for the legal and other disciplines inherent in patent rights, which are too often neglected by other analytical solutions. Over the past 3 years, MIT's Sloan Management Review and IBM's Institute for Business Value have conducted detailed analysis of the role of analytics in corporations. In 2 studies published in the fall of 2010 and 2011, their data and analysis provides a compelling case of how top-performing organizations use analytics to drive competitive advantage.
Joe, you're absolutely correct. We've seen repeatedly in numerous real-world examples and in the survey results that top performers use analytics extensively and broadly, often achieving remarkably higher performance and decision outcomes over those who touch upon light or intuition-based decision-making. In addition, what I find concerning for many firms is that the gap between the analytic haves and the analytic have-nots is increasing rapidly. Simply stated, the IBM Sloan research indicates that similar to quickening product cycles, technology development timeframes, and the like, the gap is increasing. As skilled corporate departments and firms master their capabilities, while laggards fall further and further behind. Evidence-based decisions and repeatable analysis have quickly moved from supply chain and finance into broader operations and general management and functions where patent claims can add significant value.
Alex, I've seen time and time again that business management and the legal functions fail to collaborate and communicate effectively in this key area in the use of analyzing patents. These obstacles, I think we overcome, but let me explain a little bit what I think they are. First, it's the density of patents. They're not easy for a layperson or a business manager to read. Historical data and software providers focused on search and retrieval or quantity over quality and neglected the legal nature of patents in the first generation of analytics. The level and depth of analysis greatly differs by the decision-making involved. All of these, the effective business management and use of patents involves multiple disciplines. We have legal, technical, marketing, and again, communication and collaboration has been difficult because of the lack of a common language or approach. We just look at the world differently. Alex, would you like to comment on this slide?
Joe, you're right. I can tell from many years with other firms in the industry that are focused over the years and then was on helping companies move from the public file room of the PTO, fax-based patent retrieval, and the like, to online and finally web-based research services. Unfortunately, the model did not evolve beyond finding ways to more efficiently deliver higher and higher volumes of information to more and more inundated end users and experts. With increasing patent filings, larger patent portfolios, faster business cycles, and upcoming patent statutes and regulations in 2013, the ability to quickly and effectively digest information will not abate. Claims analytics are a key component in our toolkit that companies and their counsel can use to dissect large portfolios and patenting and technology areas to support a wide range of decisions, risk and value determinations, and for the most advanced firms, scenario planning, day-to-day performance, and operational tactics and benchmarking. So, although not the only analytic or the only technique that can be deployed, patent claims are a key area of focus. In fact, by far, they're the leading components of value and risk in a patent and patent portfolio. Patent claims are the word boundaries that define the protectable right. As we've learned over the years, patents are not equal to products and can stand on their own in portfolios, such as those as intellectual ventures and other non-practicing entities. They've also increasingly become a tradable asset class or in their own right. And some industries perceive patents as the impetus for M&A and other portfolio-specific transactions. More traditional industries are also developing awareness of the value of patent claims, as investors in management seek to move from quantity measures of how many patents companies have acquired or accumulated to quality measures to see if they're getting good returns on their investment in these patent assets.
Unfortunately, reading patent claims across a full portfolio or a technology landscape has simply not been feasible. So consider if we, as a rule of thumb, an expert looked at a patent claim every 5 minutes. This would often result in a multi-million-dollar legal bill when spread out over a course of several months. And worse would be the fact that this is a one-time subjective and non-repeatable outcome. Would the same patent be rated the same way the second time through? IPVision was tasked with overcoming this challenge by Sun Microsystems and other leading technology firms. At their behest and in partnership, we developed an expert system based on dozens of algorithms to provide critical insights into patent claim broadness and structural quality. Although based upon many complex metrics, we focused on the ability to communicate and collaborate with the results by providing an initial measurement that can result in one of 15 possible combined variables, which can then be dissected to support more granular analysis. So what we do is we rank based on broadness, the breadth of a patent, and the structural quality. 1 meaning we don't see any obvious defects in the structure, and 5 meaning a potentially fatal defect, such as an incomplete sentence or a lack of a verb. We combine these scores into a range from A1 to C5. Let's see a few more of these examples in action, so you'll have a better feel of what we're talking about.
Okay, thanks, Joe. As indicated, patents are increasingly becoming the focus of transactions, either in driving the acquisition, sale, or other activity around the business, or in specific portfolio-based transactions. In fact, the newspaper this morning, or electronically if you read on your e-reader or your RS feeds and the like, the big news was Kodak's listing of 1,000 patents and its bankruptcy filing with an auction to as many as potentially 20 interested parties. There are many other specific examples, and in the next few slides we're going to review 1 or 2 of those from the telecommunications industry. So, needless to say, nearly anybody who operates in the business world or as a consumer is aware of what's happening in the patent space and the telecommunications sector because it's reached the popular press. It's in the throes of the patent wars or patent disputes, depending upon how you phrase it, whether over touch screens, wireless standards, battles over specific components, or even market share and access to certain countries with devices. The impact for each firm, their investors, and the broader economy is considerable. So just looking at this wireless space in particular, more recently, Google, in a reported response to the sale of Nortel's patent portfolio to a consortium of its competitors, acquired Motorola Mobility, both the patent portfolio and the business, for several $billion. As most people on this call are aware of that transaction, and most of us use at least one or represent one of the companies producing devices, products, or services impacted by that portfolio, let's use that as the first of our several examples. So what we see here is that the Motorola Mobility portfolio, in some respects, is a textbook case of patents providing lasting value to a struggling organization. After the Razor, if people remember that device, market share declined and other missteps in the wireless business, Motorola made public its desire for strategic alternatives for that division. The chart on this page shows the multi-decade investment Motorola undertook in building the patent asset foundation for Motorola Mobility, and an indication of the challenge posed to firms operating within its sphere of influence. Simply stated, how many telecom firms or other interested parties have analyzed this portfolio deeply, either pre-transaction or post-transaction, to specifically understand how it might influence their operations in the many years to come? More importantly, and for discussion example, is the need for a path to understand where value and risk may lay in the portfolio and how those specific positions may evolve over time or relate to one's own corporate strategic imperatives. If the portfolio is monetized through licensing or litigation, patent claims will be the single most determining factor in those discussions.
So let's dive into those patent claims across the portfolio. First of all, you see that there are 16,347 claims. By this we mean independent claims. We only analyze the independent claims. Again, we do broadness from broad to narrow, A, B, C, and structural quality, 1 meaning no defect to 5 fatal. So if we move down the chart, you'll see the first section with the arrow on the left is categorized as a type of claims, system, method, apparatus, and Jepson claims across the whole portfolio. Then the next arrow down shows broadness ratings, A, B, and C. Of note here is the fact that 18.5% of the portfolio is broad rated, which is quite a bit higher than we see in comparable portfolios, often in the 10 to 12% range. The next arrow down is the structure ratings, where almost 11% have no obvious defects, and very few have fatal defects. The 4% there at the level 5 is a very low number. So This portfolio has a number of broad claims and well-structured, and when you combine these ratings, at the bottom you can see A1 rated claims 4.5%, A2 rated claims, meaning broad with just minor potential defects, at 8%. This helps us to then prioritize review in the portfolio of what are the strong patents from a claims viewpoint. When combined with things such as citation analysis, we can identify highly cited patents that are broad and structurally sound. So all of this is an example of how we can do this fairly quickly at low costs and help prioritize. Just to give you an idea, by the way, the underlying claims are available on our platform, so you can drill down and see them. This would typically be available in 2 to 3 days at a fraction of the cost of manual review, typically a few dollars a patent. While it may be nice to know Motorola's position of a portfolio at the claim level, it's also valuable to consider specific alternatives and comparables, as those should also be present in the sound decision-making process. Hence, in addition to priority review of key claims, it's important to consider benchmark or alternative outcomes, which we'll show in the next slide.
Yeah, so in this visualization and slide, we cover a lot of ground. It's important to remember that drill-down access to the specific claims and specific patent supports the overall result. So across the 5 firms, in this case, Nokia, Alcatel-Lucent, RIM, Research in Motion, Ericsson, and Apple, we provide some information on aggregate patent claim counts, claims per patent, and the important perspective of where specific broad claims and well-structured claims may fall within the portfolio. I'll explain this slide specifically in a second. So you see that, across the 5 firms, recalling that Motorola Mobility had just under 8,000 issued U.S. patents, a range of different alternatives. Nokia with about 10,000 patents, and following the red line, you can see Alcatel-Lucent's portfolio is about 60% larger. RIM's is around 2.4 thousand patents. Ericsson, 1,200, and Apple around 4,000. By the way, these exclude design patents because they don't contain claims and not be part of this type of analysis. Moving from the size or number of patents alone, we actually get into the total number of claims, which will be on the primary y-axis on the left, or the light shaded blue bar, vertical bars for each company. So you can see that Alcatel-Lucent's 16,000 patents, return, slightly more than 3.2 claims per patent, or 50,000 overall patent claims. Getting back to the difficulty or challenge faced in analyzing a portfolio of that size, or even of a much smaller portfolio where you're looking at a firm like Ericsson or Apple, where you have a few thousand patents, but still looking at several thousand patent claims that would need to be analyzed. Moving within that as a way to prioritize expert review, as a way to benchmark between firms, and a way to provide a calibration for expert review that may have been completed, the percent of claims that fall into the categories of either A1 and A2 or B1 and B2 is shown on the secondary y-axis on the right-hand side. So from that, you can see that there's a different percentage of claims or efficiency in obtaining core claims which are both broad, generally an A, and well-structured, a 1 or a 2, between these firms. So you can see Ericsson is over 10%, surpassing Alcatel, which is just over 10%, about 11. And then at a much lower level, you see Nokia and RIM. So even though Nokia has a larger portfolio than RIM, on a percent of claims that are broad and well-structured, they have not had the efficiency or the ability to obtain that. And that can be based upon our R&D concentration and activity, the level of innovation within the firm over time, the efficiency of counsel. It could be a strategic choice of where to invest funds into specific core patent rights versus others that are more just to build up a war chest. and quantity, which makes it more difficult to analyze without techniques such as this. And then the vertical straight line going up to the X will show you that next level of contributing value or supporting value, which will be your B1 and B2. Sort of the middle of the distribution, but they are well structured. So if they support or read upon a specific product, a specific standard, a specific device, software, method, process, or system, they can be very valuable claims. But they're going to be narrower, cover less technology ground, and thus be potentially easier to design around unless they're part of a standard setting organization where standards essential. So in general, given similar time frames and technologies, one would generally prefer a higher percentage and quality of relatively broad and well-structured claims over narrow, poorly constructed claims. This form of analysis also hints at how flexible and dynamic key indicators can be in supporting expert and management evaluation, particularly when married with other metrics or specific side-by-side comparisons around holdings in a specific technology area. So in the next few...
I just wanted to jump in if I could here on a couple things. This visualization really enables a whole range of discussions that I don't think really could profitably be had before. As you pointed out, assuming that we're using comparable area information such as technology areas or U.S. patent classifications. Examples for senior management can now provide some consistent patent claims benchmarking for strategy development and patent process improvement. Boards of directors now can begin to have a discussion with the company about how effective and efficient the company is being in patent management processes for the protection and improvement of shareholder value. We couldn't really do this before we had these kind of analytics, which I wanted to come back and just comment on the analytics. People might ask, well, how do I know this stuff works? Nice chart, guys, but how do we know it works? Well, we had an example recently where an outside law firm had been retained to look at a very large portfolio on a soup to nuts basis, and they were very pleased with the number of partners and associates that were going to be able to work on this. But the company that retained them really wanted the information sometime this century and was pressing. And under the gun, they had a discussion with us. They were a little skeptical at first. They had manually reviewed some 300 or 400 patents in a given technology area and had done a deep review of it. And they said, would you run your patent claims analytics across these 300 or 400 patents? Because we want to see if this stuff even works. They did. We did run it, and they looked at the results, and it was what we've seen over and over again is that our analytics do capture all of the key patents. In fact, maybe a little bit more than they would have done manually with some points for them to reconsider. And more importantly, it certainly flagged the ones that were not particularly good, thus saving all the review time. So we were slightly over-inclusive, which they liked because you don't want to leave anything out. And yet they didn't have to spend all the time reading the stuff that was really bad. And they got very comfortable on that 300 to 400 patent run, and we proceeded to run that across some 15 or 20,000 patents, greatly accelerating the time, elevating the level of discussion and analysis from the nitty-gritty data up to a higher strategic plane. So I wanted to make that point before we went any further. So Alex, maybe some more examples.
Yeah, no, it makes a lot of sense. Even just thinking about this one set of companies, if you're looking at Motorola, RIM, Nokia, it's just 3 potential portfolios to evaluate. You're looking at, in all likelihood, about 20,000 patents with about 60,000, 65,000 patent claims. So that's an incredible number to try to think you have to work through if you're either working with an analyst or a business development and strategy person, much less actually trying to do diligence on a portfolio for risk or a potential transaction. So in the next couple of moments, we'll provide a few examples related to some specific transactions and other non-transaction initiatives frequently undertaken by industry and their counsel. First, we'll review a specific or second patent-driven M&A transaction, followed by R&D and patent quality review initiatives.
Yes, Alex. Earlier this year, Real Networks closed the sale of its patent portfolio to Intel for a disclosed $120 million acquisition price. This numbered approximately 120 U.S. patent assets. The sale included several patents considered fundamental to audio and video compression and transmission, with particular importance to the upcoming product cycles of major manufacturers. While the chart on the right provides portfolio-level claims values along the A1 to C5 spectrum that we've talked about, the image on the left demonstrates how one can drill down into the overall portfolio to find a cluster of interest. Now, what's on the left is one of our IPVision patent maps. The horizontal axis is time. Each of the boxes is a U.S. patent. The left edge of the box is the issue date, and the tail to the left is the filing date. The lines connecting the boxes are the citation references, patent citing an earlier patent. So this is a cluster within the Real Networks portfolio, and what we're showing is how they're related to each other. A cluster of cross-citing patents usually indicates some degree of strength or at least investment in an area. And we've taken the claims analytics on the right and superimposed them on the map. That's the sort of pentagon shading of 5 or 6 of these patent boxes, as you can see. So these would be boxes that are high claim rated and highly cited. And so these are the ones you probably want to start and understand because high citation often means important from a technology viewpoint. And of course, the patent claims analytics says this is probably a strong patent from a broadness and claims viewpoint. So when you combine these with other due diligence, including inventories of patents, looking at families, chain of title, encumbrances, this is an example of where we can take claims analytic and remove significant time delays and risk from a transaction by providing accelerated access to critical information and a level playing field between the parties to explain and evaluate the value determinations. So again, even it doesn't require tens of thousands of patents to make this extremely valuable proposition when you combine the claims analytics with other techniques that we use. Alex, on the innovation front, yes.
Yeah, no, so moving from a transaction, one of the interesting shifts that we've seen is that firms are starting to look at patents and patent analytics more broadly than specific decisions that must sort of require a time-sensitive determination. And I think that aligns with the MIT Sloan and IBM research showing that best case or leading practice firms are using analytics in a range of general management and business management processes. So in this example, it's one where we worked with a variety of firms to look at how patent claim analytics can serve as an important indicator of R&D and innovation in an industry. For this example, we've married claims analytics with patent classifications. In this case, a technology related to computer processors. So patents are binned or bucketed and assigned to a classification scheme by the U.S. Patent Office. And we use those as a proxy for technical fields. In this case, we've chosen a relatively broad and generic section of the classification for demonstration purposes. In the engagements, we might actually become much more granular and focused and look at specific activity between benchmark firms. So, saying that, all else being equal, technology innovators and leaders tend to receive broader patent claims than active adopters who follow in those innovators' footsteps. As a diagnostic tool or early warning system, following innovation trends in a field, either broad or very specific and defined, can provide important non-judgmental perspectives to support discussions between technologists, R&D, and legal functions, and their corporate executives who are all seeking common end goal. For corporate management, the diagnostic can also support decisions related to internal capital allocations or migration between organic and acquired R&D strategies. To look at this more specifically, you'll see on the time dimension for 3 firms, left to right, their share of patenting that they're obtaining that are focused only on the breadth of the patent claims. We're not looking at structural quality now, to remove some of the legal representation question and focus on innovation and R&D. So what you see in the slide, or the chart in the upper left-hand side, is the first firm that may appear to be sort of a typical firm. It was involved at the start of the industry and received, in dark blue, a reasonable percentage of its portfolio to have broad claims, and then narrower claims at the upper two-thirds of the chart, the very top level being the narrowest claims, or C claims. The second company, Company Y on the right, again, had a similar trend where they started off and had a real lion's share of its portfolio receiving broad or A patent claims. And then over the last 2 to 3 years, you start seeing a very rapid decline. So this can be, questions of, are they falling behind? Are they exiting the business? Just, why is this happening given similar filing rates, but still, not being able to obtain the breadth of patent claims of even the first firm. And then Company Z, the third firm in the same patent class, same industry, same general space, multi-billion-dollar market that these are actual competitors in, has actually transformed itself from being, in all likelihood, a follower or somebody that was not obtaining the broad protection within that technical space, to now that over half of their patent claims they're receiving actually are in that broadest category. So if I'm an executive or an R&D manager or a legal counsel in one of these three firms, comparing the three trends can help inform where we are working well, where things can be improved, or where we may be falling behind on that innovation and technology cycle.
Yeah, I just wanted to make a comment on that. Can we go back to that chart for a second? The fact that they're in the same area, the increasing number of broad claims that Company Z is getting may very much indicate a new technology where they can stake out broader claims. Again, sort of an early morning kind of thing for discussion within the firm. So we can go to the next thing. Actually, before I dig into this, I just wanted to address a question we got that goes a little bit more to the ratings, so I could ask me to be a little more specific about how does this broadness and structure thing work. Broadness, what we do is we take the independent claims and we explode them into a variety of text vectors, measuring various attributes. For those longer claims, but we go much deeper than that using limiting clauses, noun phrases, verb phrases, etc., in weightings that have been back-tested. On the structure side, those rules are actually pulled from court cases. This is an expert system where the people helping us develop it had deep knowledge of the kinds of structural issues reported in treaties such as Delors or Chisholm, and therefore we tie these things back to the court cases. So specific rules about structure or things that create problems are tied to that. So we have some rules that look at broadness, and we have court-based rules based on the structure. With that in mind, this is a very good place to look at the quality review example, which what we're looking at here, this is a given company, and these are the law firms that prosecuted patents for that firm. The dark blue bars coming from the left side, those are broad claims with good structure. The lighter blue in the middle, those are sort of medium, and the ones big structure issues. So the question now, when we plot these things, is why do certain firms have a noticeable lower ratings, such as Firm K? They have fewer broad claims and a lot more narrow, poor quality claims. And yet Firm J doesn't look like it has any narrow, low quality, but a lot of broad claims with good structure. So this is a way we can start to ask questions across, are law firms doing the job they should? And given the cost of filing patents and maintaining them, making sure we're getting the best value from our patent prosecution can be done with these quality view examples. I think that's about all I wanted to say on this, Alex, unless you had any additional comments. We could move to the next one.
Yeah, probably the only thing I think would be to sort of restate the payback from this type of analysis. If you're spending tens of thousands of dollars per filing and millions of dollars for your portfolio, running this type of analysis very quickly can provide an immediate.
Actually, I should have made that point. In fact, that was the driving force behind the original project that we undertook to do this, where the company needed to understand how well its portfolio had been developed, and they had spent a lot of money with outside review, and they said it was cost a lot, and it wasn't repeatable, and that led down this path to could you develop patent claims analytics.
So moving from the summary analytics and statistics, which can be extremely informative and provide a range of new perspectives and stimulate conversations around whether it's transaction, innovation, and technology planning, or capital allocations within a firm, or quality review on how counsel may be representing the firm and the efficiency that they're working with the patent office and the engineers to obtain and build a portfolio. Now, one of the key questions, and every time we work with a client, it's the well-worn phrase of context is critical, or it's a crucial aspect. So when you think about how analytics can support a specific decision, you have to remember that in today's world of patents and technology environments, the context statement is just fundamental. Whether it's grand stakes of antitrust or in the weeds analysis of specific claims related to a particular product line and offering, we want to remind you that no matter how good any analytics are, including IPVision's own, it's important to have easy access to the underlying data and to develop confidence in how they're delivered. So whether the big picture of Motorola mobility, the benchmark comparables of Nokia, Alcatel, Apple, or others, that context is king. So we've moved along at a pretty steady clip. So let's transition to a few actionable recommendations and attempt to address many of the questions that are submitted during the presentation.
Yeah, Alex, can we go back to that slide again? Sorry, Alex, just wanted to explain a couple things on it. In terms of detail, in the background you see a patent map which is actually looking at the Apple patents that are citing part of the Motorola portfolio. So that's showing comparison of two of these if you were trying to assess it. The intermediate visualization there is actually a class tree analysis where you can look at the various where these patents fall in the classification system out across branches in a way that you really can't do without the kind of tree analysis we do. And the final thing is right down at the detailed claims level, showing that first one is the first claim of that particular patent and the ratings around that. So again, a number of different things to help the discussion. So now we maybe can go to that actionable item slide. We started this presentation off by showing findings from the MIT Sloan Management Review and the IBM study about data analytics, about how important that is. And we've shown you a variety of patent analytics that can be useful to help you incorporate patent insights into decision-making and processes. Here are some actionable action steps to start to use this type of information. First of all, and this is pulling off some of the recommendations from the MIT IBM study, but translating it into the patent domain. The first recommendation is that you start and develop a deep understanding of your own portfolio. And in this way, you can become comfortable that the patent analytics, claims analytics actually work, because this is a portfolio that you and the people in the organization should know better than any other portfolio. And so once you work with that and get comfortable that, yes, in fact, this does provide it's accurate and it does provide insights even in your own portfolio. Then you can start as a second thing, step 2, to start to focus on key competitors or current and future technology areas as you start to understand the patent landscape to help inform business and strategic decisions. Some companies then go on and, depending on the industry, they look at the broader value chain in what they're doing, their suppliers and future competitors, to understand where they fit in the value chain. And then taking that insights that come from looking at your own portfolio, at key competitors and technology areas, start to embed those insights into the strategy and the business processes for the company. And then finally, having done that, you want to begin to continue to maintain current awareness through structured update and review. It gets back to the age-old maxim that you can't manage what you can't measure. And so what we're saying here is that patent claims analytics and other analytics can be brought together to help you measure something so you can manage it better and get the kind of returns that the MIT IBM study pointed out that leading analytic firms using analytics are achieving. And so those are the action items that I would recommend. And perhaps it's time for some questions.
Yeah, maybe Joe, I'll just jump in and reiterate sort of the roadmap you laid out. In working with clients, oftentimes it gets into sort of the stated process. Know yourself, know others, and then make sure it's an iterative process. Otherwise, you won't get that lasting value. So that's the case of actually having a roadmap of additional follow-on initiatives as you start learning more about what's happening in technology area. You're likely going to identify unexpected activity or unexpected competitors. So make sure you actually take the time to investigate or drill down into those. Otherwise, you can be shortcoming the process.
And just like the term big data and what people are now able to do with data in other areas of business, the kind of things that we've shown here allow you to do it quickly, cost effectively, and communicate it well within the organization. So it does become a process that works and not just a one-off thing that's put on the shelf. So.
Excellent. Thank you.
So
I thought it would be a good time to grab some questions. So to Alex and Joe, you guys can determine kind of who's the best fit to answer these. The first question I have from audience is this a tool or service that you can subscribe to, or is all the work done on a project basis?
Yeah, right now this is an expert system that we drive at IPVision on a project or a report basis. So it can be a report on a portfolio. Oftentimes it gets integrated into or with other analytics, so that as we understand the specific context of our client, we can marry the claims analytics with other analysis. This could be trend analysis across technology classes, comparison against specific firms or agents and counsel and the like. So in many cases it is a report or a project with a focus of trying to support a bigger context or bigger picture rather than just having claims analytics metrics alone on a set of patents. And even then it would just be provided to our clients in report form so they can access it on our online platform and iterate or build out depending upon the context of their nature of the inquiry.
Yeah, let me just make a comment about the online platform there. The data is loaded there, but you then can link that to underlying patent data, the USPTO, and other things, including mapping. So it's a very much, it can be a very much hands-on, fully exploratory additional review once the information's been teed up there.
Excellent. So another question asked towards the end of the presentation was, many of these examples seem to be for corporate use. How do law firms use this, or can they?
Yeah, we've had a lot of experience working with law firms in using this analytic or other analytics that we provide. One of the biggest uses that we see is for law firms that are seeking to find new methods of communicating with their client and to shift from the role of expert advisor or an advocate on a specific decision or a specific transaction or a specific litigation question or specific patent filing in that matter, to finding ways to communicate across a broader business process or decision-making process and become that strategic advisor or strategic counselor role to their outside clients. And this is something that time and time again you see corporate counsel and corporate executives are seeking from their outside firms but struggle getting. So this is this technique and others that analytics provide provide a solid foundation to help the inside counsel, corporate executives, and outside counselors get to that higher level value in the relationship and speak to that. Sometimes you'll see it used for some very specific activities or initiatives as well, one of which could be looking at benchmarking their firm and their attorneys to other firms and other attorneys. Well, that could be just a quality management or quality improvement initiative. It can also be used, and we've seen this in some situations in a marketing context.
Great. So we had a question that came in post some of the specific claims analytics slides. Can pending patents with current claims also be analyzed?
Yes, they can. I should just reiterate our claims analytics, when we run them, are usually on issued patents, and we're looking at the independent claims. We're not looking at design patents. But they certainly could be run on pending applications on the theory that you want to submit the broadest application that you think you can, and also you want to make sure that there are no structural problems, realizing that the structural problems aren't going to get any better during the prosecution unless you pick them up and amend them. But the broadness is likely to decrease as examiners cite art that you have to overcome in order to get it. So if you're not putting out a broad patent that's well structured at the beginning, you want to know that before you file and have to backpedal during examination, realizing that the analytics are going to be on a different scale than they would be if they've been through the full prosecution. So people are starting to use it for pre-filing QA, quality assurance.
Great. So let's pull one more, and we'll go for one of the recent ones that came about on this slide itself. How long does it take to provide the analytics for a portfolio, and is there a general cost scheme that you guys can give us?
Yeah, with notice or a little foresight and forewarning, we can run this extremely quickly, often if necessary within a day or two. Generally, more typically, we'll see 2 to 3 days, which allows us time to do a proper QA and to work with you or a client that is, to marry this to other supporting analytics or in context to other firms in the decision that you're facing. The cost is based primarily upon volume or the different analysis that we're going to be running to support it. Generally, you're looking at single dollars per patent. So if there are 2 or 3, 4 independent claims per patent, you're looking in many cases just cents per claim. Generally, you're looking at the highest volume portfolios, $2 to $3 per patent, and then much lower volume portfolios, the other analytics that might be requested.
And Alex, let me just point out there that this is often a part of a broader portfolio analysis. And if you're looking at a portfolio that isn't your own and you really want to get depth and it's a large company, we at times go and do a full M&A analysis and everything. So the time it takes to actually assemble a portfolio and get comfortable that this is the portfolio for this company based on all available public information sort of determines how long the whole process can be. But simply running these around a given set of patents can be done relatively quickly. Yeah.
Excellent. Well, I'd like to close things out at this point. So thank you both, Alex and Joe, for going through the presentation. Thank you for all of our attendees for signing up and going through this process with us. I'll be contacting each of you individually to discuss taking advantage of an offer where we could put together a sample claims analytics report for you. And in addition, we'll be posting the webinar within a week's time on our website, and also we can send out copies of the slide deck. So to everybody who attended, and to our great hosts, Joe Hadzima and Alex Butler, thank you all. We will look forward to being in touch shortly.
Thank you, Joe.